I think I've mentioned before that on-base housing is a bit of a trip. It's not an environment where I personally thrive, and I found myself really stressed out about unsupervised children, especially after one incident during which I spotted 8-year-olds playing on the edge of a 9-floor apartment building roof, and encountered not a single adult on my way up to get them back on the right side of the fence and ultimately down to the ground floor. During another anxiety-inducing incident, I watched in horror as a child rode flat on a skateboard around a blind curve in the middle of the road. Thankfully, she was not pancaked by a car, but again, I didn't see any other adults. When living in Japan, I also met a handful of people who never really left the bases. They would just popcorn from one to another, missing out completely on the foreign country we lived in. A foreign country that had way better food than Arby's and Chili's. Apologies to everyone in the Air Force that just gasped at my assertion. I said what I said, and it could be my most controversial take yet. As someone who is perhaps overly critical of the details, I can find a lot of things to complain about, as I'm sure you've put together. So to balance my hot take on on-base living, I would like to offer some observations of what people do really, really well. When COVID hit, we had no grocery delivery services overseas. We took it upon ourselves to care for our neighbors and to make sure they had the supplies that they needed. When we personally needed a dog sitter we could trust so we could leave the island at last, our upstairs neighbor helped us with the best solution for us and for their teenager that desperately missed having their own dog. And if you screamed bloody murder because one of the banana spiders infiltrated your home and you walked into a web face first, someone would come running. So maybe it's possible that people on base are a little bit nosier. They're a little more ready to get involved, or a little more comfortable calling around for help to deal with something. Whatever it was that motivated the on-base community to contact Chief Petty Officer Woods' chain of command, doing so may have saved his wife's life. This is Conduct Unbecoming. I'm Erin, and I'm your host. In April 2022, a woman we'll call Connie grabbed her cell phone and summoned first responders to her on-base home. She shared an almost unbelievable tale of survival, describing fighting off her husband over the course of a 2-hour attack. To hear her tell it, Connie had been sleeping only to awake and find her husband, Operations Specialist Chief Petty Officer Philip Woods, straddling her. She begged him to let her leave, pleaded with him to stop cutting at her arms with a knife he held over her. At one point, she was able to escape, not just the bed, but the bedroom, before Woods hauled her back and resumed his attack. The 2 hours of chaos only drew to a close because somehow members of Woods' command communicated to him that they were on their way to check on him. Receiving that communication prompted Woods to return Connie's phone to her. But it wasn't just Connie's version that described the injuries Woods inflicted. When first responders arrived, Woods admitted to them that he caused Connie's injuries. The Coast Guard Investigative Service poured over the Woods' home. They seized the mattress cover, mattress bedding, towel, a black area rug, doorknobs, and even cut out a portion of drywall containing a suspected palm print. They took hundreds of photographs and used a scanner to build a 3-dimensional image of the crime scene. And after the CGIS released the scene, the property management company removed and disposed of the mattress and permitted Connie's loved ones to scrub away anything that remained of her attack so she could safely return to her home. By the time his court-martial began, Woods sang a very different tune. He said it was Connie that was abusive in their relationship, that she was both suicidal and homicidal. and that in the time between when she sustained the wounds which he described as self-inflicted and the time first responders arrived, Connie had convinced him that he should take responsibility for her injuries. That narrative does strike me as a bit strange. If Connie did not wish for Woods or herself to get in trouble, she could have just not called 911. In support of his defense, Woods recounted an incident where law enforcement officials transported Connie to an emergency department following reports from her family members that she was out of control and, at that time in 2017, posed a threat to herself and others. Woods argued that the emergency room visit from 5 years earlier was significant to his defense, that it would or could show that Connie was the real threat and mastermind. And he believed he could prove it if he could get her psychiatric treatment records. Connie asserted her privilege over those documents. Military Rule of Evidence 513 governs the admission of those records, and it provides that a patient holds the privilege to refuse to disclose and to prevent others from disclosing confidential communications made between the patient and a psychotherapist if the communication was made to facilitate a diagnosis or treatment of their mental or emotional condition. There used to be 8 listed exceptions to the privilege. There was no privilege after the patient passed, when the communication is evidence of child abuse or neglect, when an applicable law imposes a duty to report the information contained in a communication, when the psychotherapist believes the patient to be a danger to any person, including themselves, if the communication contemplated the future commission of a crime, when disclosure was necessary to ensure the safety of military personnel, military dependents, military property, classified information, or attaining the military mission, when the patient was the accused and disclosure is in the interest of justice, and a sort of vague, when admission or disclosure is constitutionally required. That 8th one kept getting people into hot water because military judges used it to crowbar into the privilege during sexual assault cases, and it has since been struck from the exceptions. If this sort of argument is interesting to you, I'll point you generally to episode 23, the Ellerbrock case. It's a sexual assault case in which I lamented that the vast majority of the case coverage and appellate opinion had nothing to do with the accused and his conduct. Instead, the fact section reads as a recitation of the victim's history. I believe we find ourselves in a similar position today, discussing the psychiatric treatment the victim received or may have received because the fact section in Woods is a mere 164 words and serves primarily to set up a reader's understanding that Connie received emergency mental health treatment 5 years before Woods woke her up by slicing at her arms while straddling her. Woods didn't get to just make an allegation that Connie's health history would exonerate him. He had to overcome that privilege contemplated by the military rules of evidence. The reason these communications are generally privileged is we want people to be honest with their medical professionals. We want people to be accurately diagnosed so they can receive the care that they need and don't become a danger to themselves or others. This is a concept I sort of loosely touched on in episode 20, the Easterly case. As to Woods, the judge granted the motion in part and denied the motion in part. She ordered the production of non-privileged records, but denied the production of privileged records, records of communications made for the purpose of facilitating a diagnosis or treatment. Because medical professionals are not well trained in the exception to evidentiary rules, and maybe more particularly records custodians are not well trained in the exception to evidentiary rules, the judge had the foresight to subject whatever records the hospital staff produced to her in-camera review before the records would go to counsel. But I wouldn't expect whoever processes these records to be aware of military regulations that might be applicable and strip the privilege from certain communications. When a judge reviews documents in camera, it means she reviews them without the parties present and makes her decisions from there. The original documents are usually sealed and maintained, to be submitted to the appellate court for further review if the judge's decision is challenged on appeal. So the military judge here took the 72 pages of documents the hospital produced into her chambers and discovered both non-privileged information and privileged communications. The non-privileged stuff might be the more mundane medical side of things. Her blood pressure, pulse, medicine she was treated with. As to the communications, the judge redacted what she found to be privileged and provided redacted versions to counsel. That consisted of 3 pages. The military judge explained that the records were relevant in that they tended to support Woods' argument that Connie experienced a mental health crisis in 2017 and that, at that time, she expressed suicidal ideation. His theory continued that following similar stressors in 2022, Connie expressed similar suicidal ideation and inflicted wounds upon herself. What the records didn't do was support Woods' theory that Connie was a homicide risk. The military judge's ruling prevented a trial within a trial about whether Connie was or was not a homicide risk in 2017 and whether that could be dragged forward into 2022. So those remaining 69 pages that the judge didn't produce were either privileged communications or cumulative of other testimony entered at trial. Testimony from witnesses to the 2017 incident. Ultimately, the panel convicted Woods of 1 specification of attempted murder and 1 specification of kidnapping. He was sentenced to a reduction from E7 to E1, confinement for 20 years, and a dishonorable discharge. On appeal, Woods argued 7.5 assignments of error. I give half credit for his cumulative error argument, the argument that maybe none of the other errors amount to reversible error, but that taken cumulatively as a whole, he was denied a fair trial. The purported errors I think are the most interesting are his first 2, which revolve around Connie's medical records. There's also one that sounds like a spy thriller, alleging there's a shadow judiciary. There's not much on that claim of error because the Coast Guard Court of Criminal Appeals rejected it. First, Woods alleged that the military judge erred when she concluded that certain evidence from Connie's medical records was privileged and therefore not subject to production or use at trial. He believed they were not privileged because none of the medical professionals who treated Connie in her 2017 visit to the ER were psychotherapists, that some of the redacted portions appeared to be observations, not communications for the purpose of facilitating a diagnosis or treatment, and that even if the redacted portions were privileged, his constitutional rights to confrontation and to present a complete defense trumped Connie's privilege, and he was therefore entitled to disclosure of her medical records and psychotherapist communications. As to whether or not the medical professionals that treated Connie in the emergency department were psychotherapists or in some way assisting psychotherapists, the CGCCA told him that it was his own tough luck that he never mentioned that before, arguing it for the first time on appeal. He would only be entitled to relief if it was plain error that materially prejudiced his substantial rights. Woods didn't cite any binding precedent that emergency department doctors and providers treating a mental health condition didn't qualify as either a psychotherapist or assistant to a psychotherapist. The Federal Eighth Circuit addressed the issue with respect to a physician's assistant in the emergency department, declining to extend the privilege for passing on intake information on a chart because it didn't qualify as treatment for the purposes of the privilege. That seems a little myopic because it would still seem to be a statement made in order to facilitate a diagnosis, or rather, copying down a statement made in order to facilitate a diagnosis. A district court out of Ohio upheld the privilege for communications a defendant made while speaking to a crisis care nurse for the purposes of being admitted for treatment. The CGCCA identified that the care team that treated Connie included 2 licensed emergency physicians and a psychiatric registered nurse. The fact-finding court, the trial court, didn't get the chance to develop the record further because Woods never raised that argument below. And, as to whether the judge committed plain error, The CGCCA applied the principle that error cannot be plain or obvious if the law isn't settled on the issue at the time of trial and remains unsettled on appeal. I think the most significant argument that Woods raised in his appeal regarded the tension between his rights to confrontation and presenting a complete defense and Connie's privilege, set in place to encourage access to care. This argument feels so significant because the CGCCA's sister courts, the Navy and Marine Corps Court of Criminal Appeals and the Army Court of Criminal Appeals, have both considered the issue and arrived at different results. The Court of Appeal for the Armed Forces is going to have to step in at some point and resolve the split. The NMCCA concluded that even though removing the eighth exception to privilege strengthened the privilege generally, it is the role of a military judge to use in-camera review to determine whether an accused's constitutional rights still demanded production or disclosure of the privileged materials. If those constitutional rights still demand production, the military judge is to ask the victim if they wish to waive the privilege. If a victim does not waive the privilege after the judge determines it to be constitutionally necessary, the judge might strike or preclude all or part of their testimony, dismiss any charge or charges with or without prejudice, abate the proceedings, or declare a mistrial. The ACCA came to a different result, declining to read the constitutional exception back into MRE 513. The CGCCA arrived at the same conclusion, finding that Congress and the President may constitutionally establish a psychotherapist patient privilege that, much like the attorney-client privilege and clergy privilege, applies to covered communications without an exception based on an individualized assessment of the communication. The CGCCA gives a 5-point list as to why they believe their interpretation, which sidesteps a case-by-case analysis of the privilege, is constitutionally sound. I've linked the opinion in the show notes, and for what it's worth, I find their 4th and 5th points to be the most compelling. Because CAF hasn't weighed in, I don't know that a true deep dive on those 5 points is entirely worth it right now. I have less success in predicting what CAF may do, and I don't want to lead you astray. The CGCCA and I were equally convinced that a records clerk would absolutely mix up privileged and non-privileged records. The CGCCA led off its analysis by pointing out that an unauthorized breach of the psychotherapist patient privilege was pretty much guaranteed. The court explained that the judge had 2 options upon receiving the commingled record: to return the records to the custodian to give them an opportunity to correct it, but they didn't deep dive into how many rounds a judge might be expected to go, or that it was within the judge's discretion to excise the documents she had already denied production of, those privileged communications. That wasn't the end of the CGCCA's review here because, as I briefly teased, the originals get sealed and transmitted to the appellate court, giving the appellate court the opportunity to double-check the military judge's work. Just because Woods thought that the judge redacted too much didn't make it true, and the CGCCA reviewed the records and confirmed the military judge only redacted confidential communications. For his second argument related to Connie's health records, Woods asserted that the military judge erred when she excluded a good portion of the unredacted 2017 medical records under Military Rules of Evidence 401 and 403. Woods believed that the 3 pages he received were insufficient and that the judge erred in providing so little. Weirdly, in each of my legal jobs, I found myself reviewing medical records. Often, they are repetitive and unhelpful. Rarely are they even relevant. And that's where the CGCCA had to evaluate Woods' second assignment of error. Just because evidence exists in the world doesn't mean it gets to come in at trial. It has to be relevant, and it can't confuse the issues. The CGCCA determined that the judge's reasoned explanation for excluding the evidence did not demonstrate an abuse of discretion, ultimately affirming the judgment after diving deeper into MREs 401 and 403 and briefly evaluating whether the crime scene was compromised when it was returned to the property management company and Connie. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductandbecomingpod@gmail.com or on conductandbecomingpod.com. Join me next time when we return to the issue of popping off at the sky. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.